My name's Carissa Byrne Hessick. I'm a professor at the law school at the University of North Carolina.
Well, thank you for joining us. And today we're going to be talking about your book, Punishment Without Trial, Why Plea Bargaining is a Bad Deal. So maybe you could begin by just talking about how you got to this book and what you hoped to achieve with it.
Definitely. So I come from a family of non-lawyers. Like my family, aside from me and my husband, who I met in law school, they don't know any lawyers. And but they're very talkative people with very strong opinions. And so when we get together for Thanksgiving or family reunions, they like to talk about the things that they care about. And several years ago, when I became a law professor, a criminal law professor, we would talk more about crime and the law. And it became pretty clear to me when I was having these conversations that, my family members, nice people, had an impression of what happens in the criminal justice system that just isn't accurate, right? They assumed, as I think most people do, that if you are accused of a crime, then you'll have the opportunity to have your day in court, have a jury of your peers decide whether they believe you or they believe the government's witnesses, and only where there's no reasonable doubt that the person is guilty will those jurors then end up convicting. Now, it's perfectly reasonable for my family members to have thought this was true. I think most Americans think this is true because, that's what it says in our Constitution, or every time you turn on the television or go to the movies and it's, and it's something about crime, this is how factual disputes are dealt with. But that's actually not what happens at all. The vast majority of cases have defendants pleading guilty, and they plead guilty because there is tremendous pressure on them to do so. So what would happen to them if they were convicted at trial is many, many, many times worse if they're accused of serious crimes than what would happen if they agree to plead guilty. And so the situation we have is one where we know that some innocent people end up pleading guilty. And we also know that people who are guilty of crimes end up getting much less serious punishments than the laws that are on the books. So it's sort of a, it's a situation where no matter what you think is important, you should probably be upset about plea bargaining. So basically, I wrote this book so that I could win arguments at family reunions, but also because, the United States is pretty unique in the fact that we control our criminal justice system through democracy, right? We vote for our local prosecutors, we vote for our sheriffs, our legislatures, whether it's Congress or your state legislature, they spend a lot of time making changes to the criminal laws. So we do all of this democratically. But if people don't really know what's actually happening, then presumably democracy is not acting as a very good mechanism to make sure it's doing what we want.
Well, let's talk about what's actually happening, because it seems to me that that's the root of some of the confusion. And let's just take a misdemeanor as an example. You have many in the book, and you begin with someone who's innocent, but let's just say someone's arrested for some misdemeanor crime. Where would the plea bargain that we're talking about come in versus where would a trial come in? And what's the difference between those two?
That's a great question. So I think part of what you need to recognize when it comes to any criminal case, including misdemeanors, right? Not particularly serious crimes where, the punishment, if you were going to spend any time in jail, it would be less than a year. Oftentimes misdemeanors are just punished by fines. There'll be pressure on people right away if they've been arrested for a misdemeanor to plead guilty. And the message will be, just plead guilty, get this out of the way. If you're being held on bail, oftentimes the first time you'll appear in court, you'll be given the option to plead guilty and go home, or plead not guilty. And if you can't come up with a sometimes significant amount of money to be let go, then you have to stay in jail, which no one wants to do. But even if you aren't, right, even if you aren't being held in jail, and let's say you get assigned a lawyer, or even let's say you can pay for your own lawyer, the lawyer is almost certainly going to begin the conversation with talking to you about how he or she is going to negotiate with the prosecutor for the best outcome. Because that's just what we do, right? Like that's just the culture right now, is everybody expects cases to plea bargain. And so if you expect your case to plea bargain and you're a defense attorney, you might as well get on that as quickly as you can and try to negotiate the best deal that you can for your client. So that'll be the assumption in the background. Even if you're a sort of stubborn person who wants to go to trial, sometimes the prosecutor will make it sort of too attractive to walk away from that. They'll say like, okay, we'll just do like a Saturday of community service or something like that. And if you keep saying no, you have to keep coming back to court. You have to sit in a courtroom, usually for hours and hours and hours at a time, waiting for your case to be called. I don't know how flexible your job is. I'd have a big problem if I were going back to court every 4 weeks or so for a conference where nothing was really happening. It was just being set down again for another date going forward. So even if you were what academics like to call a rational actor, so someone who doesn't let their emotions get in the way, they just calculate the costs and the benefits. If you're looking at the difference between, having to pay a $2,000 fine or go to trial and potentially get acquitted, it's not going to take too much for somebody to realize that having to go back to court all of those many times, maybe pay for a lawyer to go to court all of those many times, it's actually fast. It's more efficient for them. It's more cost effective to plead guilty and to write that check than it is to try to fight and say that they were innocent.
Yeah, and the process is pretty much the same as severity of crime goes up, correct? So let's say as you start racking up felonies or federal charges, these plea bargains are in place at every step of the way, correct?
That's right. And as the crimes get more serious, the dynamic looks a little bit different, because now it's not just like the inconvenience of coming to court, and if you get convicted, it's not that big of a deal. It's that if you get convicted at trial, the penalties are really severe. And so you're pleading guilty to to protect yourself from some pretty serious consequences. So I think what most people don't realize is that if you commit a crime, like let's start out and let's just assume that you're guilty. Like let's say that you went to a gas station and you threatened the cashier and took some money. Now you might just think like, oh, okay, well that's robbery. That's one crime. But there'll be other crimes that you get charged with too. You'll get charged with a theft crime. You'll get charged with an assault crime. And I'm just sort of saying like categories of crimes. If you actually dig in to the law books that every state has of the statutes, right, the written laws that the legislature has passed, you'll find that there are lots and lots of different ways to charge this thing. So a prosecutor could bring 6 or 7 charges against the person who went in to rob the gas station, and the person could be facing decades in prison. And what they'll get offered is something that's much better than that, right? Maybe attempted robbery, which they would only have to serve, maybe a year, maybe 2 years. Maybe they could plead it down to something that's not even actually what they did. Maybe they're worried about, maybe you live in one of those states where violent crimes get treated much worse than nonviolent crimes. Maybe your defense attorney can work out a sweetheart deal where they get you for aggravated theft, which would be a property crime instead of a violent crime. So the concept, you can really minimize the bad consequences, but it's even more than that, right? Which it's not just minimizing consequences. It's to the extent that the prosecutor says, hey, I'll give you this deal, and you don't like that deal, they can usually come back in and make it worse. They can usually come back in and add more charges. they can come back in and say, oh, I see that you did this while you were out on parole. I'm going to, make sure that you get sentenced as a repeat offender. And so you'll go to jail for even longer. So at that point, what you have is you have the ability of the prosecutor to increase the penalties so high that it would be irrational for someone to say no, right? If they're offering you a good enough deal, you can actually, this is going to sound silly, you can do the math to figure out if you've gotten a good enough deal. So let's say the prosecutor says, I'm going to put you in jail for 10 years unless you take this plea bargain. And you think you've got a pretty good shot of getting acquitted. You think 50% chance that the jury will say you didn't do it. If the prosecutor is offering you only 2 years in prison, you would be irrational to pass up that deal, because it's like, I don't know if you have these friends who tell you like it makes sense to buy a lottery ticket now. It's because the jackpot gets so big that even though the chances of winning are small, the expected value of the ticket is more than what you pay for it. So it's the same thing with these crimes, right? If you're facing 10 years in prison and you only have a 50% chance of getting convicted, your expected punishment is 5 years. So if they're offering you 2 years, you should jump at it. You would be silly, you'd be irrational to not take it. And prosecutors know this, right? Like prosecutors aren't dumb. Like they have a sense of what would be attractive enough that the defendant's not going to say no.
That's one of the kind of incentives that people have in taking plea bargains, but there are others. And I would like you to talk about some of the others, like the bail, and how bail kind of works in these situations of plea bargaining, and some of the other fees and costs that are associated, that are kind of used in that calculus that you were talking about, of like, how do I hedge my bets, and what's the most cost effective for me as an individual?
Sure. So let's just use bail as an example, because I think it's a really good example. Usually if you get accused of a crime, assuming that it wasn't like a super violent crime, and assuming that you don't have a lengthy criminal record, there'll be an opportunity for you to stay out of jail while your case is progressing and you get out on bail, right? And the idea of bail is that you put up some money to guarantee that you'll come back to court. The problem is the amounts of money that they're asking people to pay, right? So, and I talk about this a bit in the book. So like, let's say I'm accused of bribery. Some places the bail will be $40,000 for me to get out. And I don't know about you, I don't have $40,000 sitting in my bank account. So I can't just write a check to the court for $40,000. So what I'll do instead is I'll find a bail bond company, a bail bondsman, right? They could be women, but bail bondsmen. And the bail bondsman will agree to serve as like a guarantor that I'll come back. I'll pay them a fee, usually like 10%. So I'll write a $4,000 check to the bail bondsman. The bail bondsman doesn't have to give any money to the court unless I don't show up. But then when I show up, they never pay anything, but they keep my $4,000. So just by getting swept up into the system, you could be out all of this money. I mean, even if, let's be clear, even if prosecutors eventually agree with you and your lawyer that what you did wasn't illegal, or they have the wrong person, you're never getting those $4,000 back from the bail bondsman. That's just the price of doing business. That was what you paid to secure your freedom. So as you might imagine, people who don't even have the $4,000 to pay the bail bondsman, you see this in misdemeanor court all the time. They'll come in. The question is whether the court is going to ask for bond or not, ask for bail, set bail, or if they'll release them on their own recognizance. If they release them on their own recognizance, then that's great. That means that they don't necessarily have to pay anything. But if they set bail, we have studies showing that the chances of somebody pleading guilty and pleading guilty quickly, if bail gets set, goes up pretty dramatically. So what is bail really about? It's really about making sure that this system we have is worse if you're poor, right? Not worse depending on the crime that you committed, but worse if you're poor.
Yeah, because even $4,000 is a lot of money to a lot of people. So even giving that to the bail's bondsman is a hardship. But there are other hardships baked in as well. And I one of the things that I was talking to a friend of mine about is this pretrial detention. And they were shocked to think that there are people sitting in jail for years at a time, just waiting for their trial to happen because they can't make bail or they're denied bail. And so could you tell us how that works?
Yeah, so for reasons that kind of escape me, we in the United States have slowly moved away from the idea that we only punish people after they've been convicted at trial. Now, don't get me wrong, if back in colonial times, if you committed a very serious crime, they weren't going to just let you out and walk the streets. But nowadays, it's become pretty standard to detain people before trial, like really pretty standard. There's a professor at the University of Utah, Shima Baradaram Baughman, and she's done a bunch of historical work on this that looks at just how often people get arrested, right? As opposed to just being given like a ticket and being told to appear in court, like get arrested, like you see on TV, like they come and they put you in handcuffs and they put you in jail. We do that so much more often than we used to. And then we're much more likely to demand bail to let someone out or to deny them bail and say, no, you have to stay in jail while your case makes its way through the system. Now, if you have a system like ours where most people are going to plead guilty anyways, maybe that doesn't seem like such a big deal. And administratively, what we end up doing is we say that time that you spent in jail before you pleaded guilty, we'll give you credit for that time, credit for time served. We even have a phrase for it. It's so common. But for people where the government's case falls apart, which happens more often than you might think, if the government's case falls apart, those people don't get any sort of compensation. They just sat in jail for weeks or months, or in some few cases, years. A lot of them, they lose their jobs. Most of them, it destroys personal relationships. If these people are parents, they'll lose custody of their children. There's also a lot of research showing that putting people in jail increases the chance of them committing crimes in the future because it's so destabilizing to them and their lives. But that's, for some reason, in America, we seem pretty willing to live with it. I mean, if you've been following the debates, there's a few different states in this country that adopted what's called bail reform, which just means that they came up with some crimes where they said, look, the judge, if you've been accused of bribery, if you've been accused of public urination, if you've been accused of any number of crimes that just don't seem dangerous, then they can't hold you in jail. They have to let you go. And then invariably what happens is one person who was out while they had charges pending will commit some other crime. And then all of a sudden people will say, oh, that's because of these bail laws. Like why is anyone being let out? We need to keep them in. One of the themes, I guess it's a theme of the book, but I think of it more as a theme that I discovered, and theme doesn't convey how depressing it is just how little, the principle of innocent until proven guilty seems to matter in the United States anymore. We actually seem to assume that most people are guilty, and if not guilty of this thing, then guilty of something else. And even if they weren't, it's better to have a system that doesn't let guilty people go free. So we seem to have turned, the presumption of innocence on its head, and a lot of people seem okay with that.
Well, and I think that's a good time to kind of bring up this, like, how did we get here? How did we go from a constitutionally protected rights of, all these different things, trial by jury, evidence, confronting your accuser, to this like very efficient and very kind of punitive system? I mean, it's now, as you said, I want to pull that out, is that punishment is now really the point at every level. And how did that get systematized? How did that get, right? How are we now living under this punitive system?
It's so hard to say, probably because there's more than one cause, right? I mean, I often wonder when I teach I teach first year law students and I teach them about criminal law. And I often wonder when I talk to them about the Constitution, so much of which, like the Bill of Rights, the first 10 amendments to the Constitution, so much of it is actually about providing protections to people who've been accused of crimes. So the people who founded this country, they were very worried about the power of the government over people who were accused of crimes. And I have to say, like, I wonder if it wasn't just a moment in history where all of the people in a society had seen government abuse and been so concerned about it that they thought if they were going to create a government, one of the most important things that they had to do was protect individuals from abuse. But as time's gone on, right? I don't think that that's foremost in people's minds when you talk to them. I should qualify that, and I should say, there are people, they subscribe to a political theory of libertarianism, which is this idea of sort of freedom from government control. And my book's been very popular with the libertarians. I've been asked to speak on many podcasts run by libertarians because they see what's going on in this system as, sort of all of their worst fears come to pass, which is that the government has too much power and this is what they do with it. They oppress the masses. I think what's happened as time has gone on, most people don't think that they are going to be falsely accused of a crime or accused of a crime at all, right? Even if it's a correct crime, like maybe you owed a little bit more taxes. Instead, I think most people are concerned about being a victim of a crime. And the news tells us about other people who were victims. You go, if you live in a small town like I do, you go out to a big city and you see disorder, right? You see homeless people, you see people who are doing drugs, and it's scary, right? And you worry about your personal safety. So I think a lot of what's happened is people started worrying about personal safety more than they started worrying about government overreach. And we wanted to have a system that would make sure that guilty people got swept into the system. But I think another thing that happened was plea bargaining actually started happening in private. Like most people didn't know that plea bargaining was happening. And in fact, in like the first 100 years or so of this country, if people found out that a prosecutor was willing to drop charges in return for somebody pleading guilty, so offer a plea bargain, there would be a big outcry. People thought that was corruption. People thought that that was totally inappropriate. They had laws on the books. Those laws should be followed. The prosecutors had no authority to do that. And you actually have a number of court cases from around the time of the Civil War and afterwards where courts would see, it would come to light that something like this had happened, and they'd say, you can't do this. And they'd say it wasn't permitted. Even the Supreme Court had a case that sort of touched on plea bargaining, and they were like, yeah, you're definitely not allowed to do that. But the truth was, like, we didn't fund the courts very well, and they had, especially in big cities, a lot of cases and not enough personnel. And so it was just easier to dispose of cases like this. So they did it in secret for a long time. And then around the time of like the 1920s and the 1930s, during something called the progressive era, or like, which I know progressive has sort of a different meaning today, but back then it just sort of meant like people who thought, oh, the world was becoming more complicated. We should do things like use science to make decisions. They advocated for the creation of federal agencies like the Food and Drug Administration that could give advice to Congress, or Congress could even say, tell us the things that are dangerous that we should say are illegal. This was the progressive movement. And so during the progressive era, there were efforts made to figure out what was happening in the court system, because it's not always clear from the outside what's happening. And so these big studies were conducted. One was in a big one was in Cleveland, Ohio, but there were studies in other states across the country. And these committees studying the courts discovered that plea bargaining was widespread. And I think the point at which everyone realized that it was happening everywhere, there was a sense that you sort of couldn't put the genie back in the bottle. And a few decades after that, plea bargaining finally made its way to the United States Supreme Court. And even though there are lots of legal rules that I teach my students about that suggest that plea bargaining should not be allowed, the Supreme Court was very upfront that they were being practical and that it was already happening, and that if done right, it could be good for the system. And then after they sort of gave plea bargaining their blessing, the Supreme Court, I think, has been unwilling to do anything that might slow it down, right? So people will come in and say, but what about this type of plea bargaining? It seems especially bad. And I say, well, we don't want to get in the way of the government being able to dispose of their cases efficiently. And they give speeches about how it's important to be very efficient, and they don't have enough money in the courts and those sorts of things. So at this point, I'd say the people within the system, the people that I talk to, the judges, the prosecutors, the defense attorneys, they're just kind of like, this is the way it is. And you don't be an idiot, know how the system works, and then do your job as well as you can within the system. So at this point, I think we've come sort of to the point where it's just, this is what everyone does. The same way that like, everyone used to wear hats. Not for any good reason, as far as I can tell. You had to wear a hat all the time. Women had to wear gloves. We sort of stopped doing that. It's culture. It's just what people do, and we don't even necessarily think about it anymore.
Well, and that brings me to our Supreme Court Justice, Michael Donnelly, who factors very well in your book, and he is one of our Ohio Supreme Court justices. But he has a different take on plea bargaining, and it kind of will wrap us up with what can be done and what people are doing about it. Because I saw a lecture years ago in which some law professor said, the first thing you have to understand about court is everybody is lying. So at what point are plea bargains based on lies, and what did Donnelly do about it?
Yeah, so I think I'm a little fascinated by Justice Donnelly, because as I interviewed people for this book, I would inevitably talk to someone who would say, yes, this is a problem. Someone should do something. And inevitably, it was someone else who was supposed to do something. Justice Donnelly, I think, had the opposite reaction, which was, as you may know, he started his career as a prosecutor, where he plea bargained cases because that's what people do. And then after some time as a prosecutor, he went into private practice. And then after a career in private practice, he decided to stand for election to be a trial court judge in, tell me I'm pronouncing it right, Cuyahoga County. Okay, I'm just saying, hard to pronounce these words sometimes. Cuyahoga County. And when he was on the bench, I think, according to him, it was sort of business as usual. But as time went by, he started to get uncomfortable in his new role as judge, because in Ohio, and this doesn't happen every place, but in some places, including Ohio, the attorneys will meet with the judge. They'll have like a settlement conference, basically, which is basically like a meeting, like a private meeting, where they talk about how to resolve the case through a plea bargain. And Justice Donnelly got really uncomfortable because things were being said in those sort of private meetings that were not being said in open court. And some of the negotiations, what people were willing to live with, clearly weren't they weren't sort of truthful representations of what had happened. And so he gathered a bunch of information about case files, and he was particularly concerned about sex crimes. So he found these cases, and there's a whole spreadsheet for it, and it was really sobering to read through these. But say, for example, there's a case where a woman has accused a man of raping her, and the man denies it, and the prosecutor gets in a room with the defense attorney, and they negotiate that the defendant will plead guilty to a certain type of assault. So not a sex crime, just an assault. And if you read the law that this particular charge is associated with, you'll see that it's not a particularly aggravated form of the crime. It's a sort of mitigated form of the crime, and it's mitigated because the victim is somehow at fault. Like in the law, it sort of explains that. Now, nobody thinks, right, that the victim is at fault for having been raped. Nobody does. Like, that's just wrong. They either think that this man raped the victim, or presumably they think the man didn't rape the victim. But nobody thinks that there was an assault in which the victim was somehow at fault. But this is the agreement they're able to come to because of what the punishment is associated with this particular crime. And so Justice Donnelly, I think, correctly got upset about the fact that he was taking guilty pleas to crimes where people agreed that whatever happened, whether the defendant was innocent or guilty, this isn't the crime that the defendant committed. So Justice Donnelly, knows that there are not just laws that get passed by the Ohio legislature, but also court rules that are controlled by the state Supreme Court. And so he made a recommendation to change the rules, to change how sort of plea bargainings were conducted, to make them more clear and transparent. And the Supreme Court said no. The Supreme Court of Ohio said no. So he ran for office. He ran to become a justice on the Supreme Court. And as far as I know, they still haven't changed that rule, but I assume he's just waiting for some more folks to agree with him to get elected to that office. So it was refreshing to talk to him. Now, I'll say, I don't want to speak for Justice Donnelly. You should interview him. He's brilliant man. I don't think that he's opposed to plea bargaining in the abstract. Like, I don't think he thinks only trials are appropriate ways to resolve cases. I'm less comfortable with plea bargaining, but then again, like I'm an academic here with all of my books, right? Like, I'm not sitting in a courtroom trying to process all of these cases, but I'm really grateful for him and the attention that he brought to it, because I think there are now, because of his campaign, far more people in Ohio who know about what's happening than in other states. And I'll tell you, just because Justice Donnelly had such a high profile on this issue, I got asked to speak on a radio show several months ago. They interviewed Justice Donnelly, they interviewed me, and they also had a gentleman from the Prosecuting Attorneys Association. And the prosecuting attorney and I got into a little bit of a back and forth. And he said, look, there's nothing wrong with these pleas. And I tried to sort of explain what was going on and what my objection was. And he said, you don't understand. If we don't take the plea to this lesser form of assault, the person would probably be acquitted. We wouldn't be able to convict them of anything. I have to say, I think that's worse. That's someone telling me, I can't prove that this person committed a crime, but I'm going to pressure them into pleading guilty to something that they didn't do because I can't prove the thing that I think they did. That gets me back to the people who created this country being very concerned about government abuse. That's government abuse right there. If you don't think that that you can prove that the person committed the crime, then that person is supposed to go free. Am I concerned that the government thinks that they can't prove a whole bunch of sex crimes? I am concerned about that, but I feel like we should do something else to fix that problem than just say, let's pressure people into pleading guilty.
Well, that's an incredibly important point, and to me, terrifying. But that's, you know, a different a different conversation. As far as, like, you know, that whole idea of, you know, once you're caught in the system, there's no getting out, right? And the only way out is to admit some sort of fault, even if you're innocent. And I think that that's the takeaway from the book I got. And, you know, there are people who can't get out, you know, who are constantly touching law enforcement, or, you know, the impoverished and the racially profiled and all this kind of stuff. So having said all of this in like 2 or 3 minutes, what would you do about it if you could change it?
Yeah, so look, I would make lots of little technical changes, right? Because I think we got here slowly through that long process after the Civil War that I talked about. So there's not one fix. We could do things like not make people who are accused of misdemeanors keep showing up to court to all of those status conferences. There's no reason to do that. We could impose some sort of rules around plea bargaining where the government has to turn over all of the relevant documents and statements that they have so that defendants have a better sense of how strong the case is against them. We could get rid of mandatory minimums. We could try to address pretrial detention and bail so people aren't pressured into pleading guilty. But I think the biggest thing that we have to do, and this is a little bit self-serving, we have to have people understand that this is how the system works, right? So that when my state senator goes on the news and says, this crime was committed down the street from you, what we need is a new mandatory minimum sentence to make sure that people stay in jail, I know that that mandatory minimum sentence is only going to be used to pressure people into pleading guilty. And I'll tell you, I do have a tiny bit of hope. Since I published the book, I've had many people that I know already in my life reach out to me to say how glad they were that I'd written the book because their cousin or their uncle or their brother-in-law got pressured into pleading guilty for something. Now, usually these are people who they were sort of, you know, middle-class folks. So they were able to get a misdemeanor conviction instead of a felony, and maybe they didn't spend any time in jail even, but now they have a criminal record. I actually think I understand why I didn't know about that. I think people are ashamed about these things. They don't want to talk about them. But I think the more people who understand that the system traps you in and you have to fight really hard to try to prove that you're innocent. And sometimes it doesn't, right? Proving that you're innocent just means that you go to a diversion program so that you can maybe not have a criminal record at the end of it. That's what proving innocence is for most people in America. You know, call me idealistic. I do think that even though people care about personal safety and they don't want to be victims of a crime, I do think that most Americans would understand if they knew more about our system, that we shouldn't have this system, that it's not just and it's dangerous for us to have it because any of us could be swept into it.